Hello everyone. In this lecture series, we are going to start the Land Acquisition Act 2013. So, the full name of this act is the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. In short, we will call it as the Land Acquisition Act 2013. Before going into the meaning of land acquisition and the laws governing the land acquisition, let us understand the doctrine on which the land acquisition is based. So, the land acquisition is based on the doctrine of eminent domain. The origin of the doctrine of eminent domain dates back to ancient civilizations where rulers wielded authority to acquire land for public purposes like infrastructure and project development. So, this doctrine has originated in the ancient times where the rulers wanted to develop their area or the country. It is important to introduce infrastructure and project developments. That is, it includes the construction of roads, dams, hospitals, schools. All this comes under the activities of civilization. So, for these purposes, the government needs land. So, the land is in the control of the public or individuals. So, the government shall acquire land from individuals for these purposes. The power of government, so that power which the government have for acquiring the land from public is called as the eminent domain. So the doctrine of eminent domain is a legal doctrine that gives the government authority and empowers it to acquire private property for public use, having regard to the fact that the landowners are fairly and proportionately compensated. So it focuses on two aspects, that is providing land for the government for any public purpose, that is the infrastructure or any construction purposes or any other public purposes. So for that the government may acquire land, and at the same time the government shall make compensation to the affected persons, that is from whom the government had acquired the land. So the provision related to the doctrine of eminent domain is enshrined under Article 300A of the Constitution of India, which provides that the state cannot take individual property except by legal authority. So Article 300A of the Constitution provides that the state can acquire property, but there are certain exceptions. That is, it shall follow due procedure of law and it shall pay adequate compensation to the affected persons. And it also includes many other steps which shall be followed by the government for acquiring the land. So, the doctrine of eminent domain is not directly mentioned under the Constitution, but Article 300A of the Constitution provides that the state can only acquire the property by legal authority. So, this is what the doctrine of eminent domain states, that the state can acquire the property of individual by compensating the land owners. So, the same provision is enshrined under Article 300A, that is, the state can acquire the property only by legal authority. So, now let us understand how land acquisition is done in India. Land acquisition in India refers to the procedure by which union or state government in India acquires private land for industrialization, advancement of infrastructural facilities, and the urbanization of privately owned lands, and offers compensation to the impacted landowners as well as their rehabilitation and resettlement. So, it is the process of taking land from an individual for some public purpose, which includes industrialization, advancement of infrastructure, etc. So, for acquiring that portion of land, the government shall pay some compensation to the land owner. So, this process is called as land acquisition, which is regulated by the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013, which came into effect from 1st January 2014. So, before 2013 also, lands were acquired by the government. So, let us understand what was the legislation which controlled the land acquisition before 2013. So, during the colonial period, India witnessed the consolidation of British power. which in turn led to the establishment of Crown rule. The British introduced the concept of greater sovereignty, empowering them to acquire larger territories and resources for economic and strategic gains, followed by the Land Acquisition Act 1894, which allowed the government to acquire private lands for public purposes. So, the British government, for the advancement and for economic and strategic gains, have introduced the Land Acquisition Act of 1894. So, before the Land Acquisition Act 2013, this was the legislation, formal legislation, which was introduced by the British government for the regulation of land acquisition. However, it was heavily criticized for several reasons. So, the Land Acquisition Act 1894 was criticized due to some drawbacks. Those were the inadequate compensation, lack of transparency, absence of provisions for rehabilitation and resettlement of displaced persons. So the land was acquired from the individuals, but they were not compensated fairly, and there was no provision in this act, the Land Acquisition Act 1894, for the rehabilitation and resettlement of displaced persons. So, rehabilitation or resettlement means providing some other place or some other land where the displaced persons could start a new life. As the government have acquired the land, as the government had acquired the land from the private individuals, now they have to shift to another place. So it became difficult for them to find a new place where the individuals could find similar facilities as before. So no provisions were in the previous act, that is the Land Acquisition Act 1894. So the Indian government, recognizing the inadequacies in the 1894 Act, have passed the new legislation, that is the LARR Act of 2013. So this is the historical background for the introduction of the new act, that is the Land Acquisition Act 2013. So let us understand the salient features of Land Acquisition Act 2013. First is the payment of compensation. In rural areas, compensation is 4 times the market value, and in urban areas, it is twice the market value. So, if a land is acquired or taken by the government, in rural areas, the compensation shall be paid 4 times of the market value of the land. For example, let's say the land value is rupees 1 lakh. So, 4 times the land value shall be paid if the land is in rural area. So 4 times is 1 lakh into 4, that is 4 lakhs. So if the land is in urban area, the compensation shall be paid twice the market value, that is 2 lakhs. So this higher compensation aims to ensure that landowners are fairly compensated for their loss, taking into account not only the current value but also the potential future benefits had they kept the land for personal development. So, this procedure of increasing the compensation was introduced to ensure not only the present loss but also the future loss which the landowners could have incurred. So, let's say there is a land, the market value of the land is 2 lakhs, but in future the landowner may construct a building, so the land value increases. That is, it may increase to 10 lakhs. So this future loss is also kept in mind by the new act, and the higher compensation is paid to the landowners. And the next feature is consent requirement. Unlike the previous law, the LARR Act of 2013 requires consent of 70% of landowners for public-private partnership projects and 80% for private projects. So if the infrastructure project or the project is done by the public private partnership, that is the government and the private developers, that is the agreement between the government and private developers, that is called as the PPP projects. So in that cases, the 70% of landowners consent shall be given. And in case of totally private projects, 80% of the consent is required. So this provision empowers the landowners, especially in cases where large scale projects like factories, highways or dams are concerned. If the government wants to acquire large areas of land In that cases, consent, that is, there is a huge amount of land in which there are 100 houses. So at least 70 people shall give the consent for land acquisition in cases of public-private partnership. And in case of private projects, 80 people shall give the consent. So this is also a new feature which is added in the Land Acquisition Act 2013. And the next feature is rehabilitation and resettlement. Apart from compensation, the Act mandates a comprehensive rehabilitation and resettlement package for affected families. This includes housing, employment opportunities, and various other amenities to ensure that displaced people have a stable future. So, the new act has also introduced the process of rehabilitation and resettlement by not only giving the compensation, that is the amount or the market value of the land, the act has also provided the rehabilitation of the affected families. So, for example, if a person have purchased a land and constructed a building on that land by thinking that the area in which the building is constructed is near to his office and his children can go to the school easily, and the location is in such place where hospitals, markets, or any other facilities is accessible. So now the government wants to acquire his land for the purpose of widening the road or for any other purpose. Now he has to shift to another place which have all that similar facilities which he had before. So it became difficult for that persons to find a new place which provides all the same facilities. So this act have introduced for the rehabilitation and resettlement of that persons to a similar place where he can get the employment opportunities and other amenities which he had before. And the next is social impact assessment. The act introduces the requirement of social impact assessment before land is acquired. So this is conducted by the government before acquiring the land to ensure the potential impacts on the local community, environment, and economy are taken into consideration, aiming to minimize any adverse effects and involve local stakeholders in decision making. So, a survey or a study or assessment is done by government authorities to know the impacts of acquiring the land on the people and also on the environment. So, after conducting the assessment, the final report which is made is forwarded to the concerned state government. So, after analyzing the final report, the state government will decide whether to acquire the land or not. So, these are the major features which are included in the new act, that is the Land Acquisition Act 2013. So, that's all for this class. I hope you all have understood it. Thank you.